Hello and welcome to Daily News Simplified, where we take the topics from the Hindu and analyze them as per the demands of civil services examination. The topics of discussion are listed on your screen.
Now moving on to the first article of the day that has featured on the Hindu on page number 1, basically talks about the MGNREGA scheme. Now the scheme is in news because the central government has recently constituted a committee to review the implementation of MGNREGA scheme, especially to assess the program's efficiency as a poverty alleviation tool. The committee has been formed under the former Rural Development Secretary Amarjit Sinha. The committee has been tasked to study the various factors behind the demand of MGNREGA work, expenditure trends, and the interstate variations that have been generated. The committee will suggest the changes in focus and governance structures are required to make MGNREGA even more effective. Now this topic is of importance as it falls under the GS2 section as a poverty alleviation tool and various government policies that have been introduced and the issues that these policies are facing in their design as well as implementation. Further, the scheme like MGNREGA is particularly beneficial for the vulnerable section of population, for example SC, ST and women, and thus becomes important for us. The topic of MGNREGA has also been discussed on the DNS dated 1st November 2022 and was taken up by Jatin sir. Under our discussion, we'll briefly discuss about the scheme. Our main focus will be the issues that are concerning the MGNREGA scheme. We'll try to understand each and every aspect of the scheme. Now, before starting our discussion, we'll try to focus on the understanding part of the scheme and the issues that have been generated in their implementation. The detailed notes have been provided in the description section and can be downloaded therefrom. Thus, the focus should be on the understanding. Now, MGNREGA scheme was introduced to provide livelihood opportunity and security in the rural areas and is a statutory scheme which provides a guaranteed employment of at least 100 days every year to every household whose adult members volunteer to do unskilled manual work. Further, the scheme is a demand-driven program. The scheme also has provisions for unemployment allowance if an applicant is not provided employment within 15 days of receipt of his application. Further, to keep the scheme updated with the market rates, there is also provision for the revision of wage rates. Now, this is also a bone of contention which we will discuss in detail in our later discussion. Now, the wage rate for workers are notified and revised annually and it is based on CPI agricultural laborers. Further, the scheme also provides for compensation. There is compensation if there is a delay of more than 15 days from the date of closure of the muster roll in payment of wages is paid to the workers. The scheme also provides as a statutory requirement of undertaking social audit. Central government also pays for the entire cost incurred for wage payments of the MGNREGA workers and 75% of the cost of the equipment and machinery that is involved. Further, as we have discussed under the social audit, state government have to identify and establish independent social audit units to facilitate Gram Sabha in conducting social audits of works taken up. The scheme also includes the components today like that of skill development. Under skill development, two projects are of worthy note. The first is the Barefoot Technician. The Barefoot Technician program is for the training and skill development of MGNREGA workers. Now, the BFT is an educated person identified from the local MGNREGA worker household or from mates or supervisor and is trained in civil engineering concepts training modules such that he acquires required skills for the identification and the estimation of works, and the minimum eligibility for the same is 10 standard education. Preference is given to the barefoot technician from the local areas, and there is also a clause for adequate representation to be given to SC/ST and the women candidates. Another initiative of skill development here is Project Life, that is livelihoods in full employment. The project aims at promoting self-reliance and improving skill base of MGNREGA workers, thereby improving livelihoods of MGNREGA workers so that they can move from current partial employment to the full employment status and thus in turn reducing their dependence on NREGA. The program focuses on skill development and formation of production groups with target households. Now, to understand more about the scheme, the DNS dated 1st November can be referred to. Now that we have seen about the details of the scheme in brief, we'll try to understand what are the issues pertaining with the scheme at a glance and then discuss them in detail. The first issue with the scheme is the low wages that are being paid under the scheme. Further, other issue challenging with the scheme is related to the problem of technology or the tech. Third is the insufficient budget allocation which is made to MGNREGA. Fourthly, irregular payment delays have been noticed under the MGNREGA scheme. It is also seen that workers are often penalized for the administrative lapses. There is also issue of banking involved while making the payments to the workers. The MIS data is also faulty at various places. There have been issues of non-payment. Job cards is also an issue. Excessive centralization and disparaging the authorities of the local bodies like Panchayat is also an issue. And dishonoring local priorities has also become an issue in the recent times. Now we'll discuss the issue in detail one by one. The first issue that we will take is related to the wage rate. Now, the MGNREGA has been criticized for its ridiculously low wage rate. The MGNREGA wage rates are less than the corresponding minimum state rates. Though there have been various judgments that upheld that MGNREGA wage rate cannot be less than the minimum agricultural wage rate of that state, the ridiculously low wage rates have been resulted in a lack of interest among the workers in working for the MGNREGA schemes, making the way for contractors and middlemen to take controls. Further, recently there was also an issue of wage revision under the wage rate problem. The government notified the wage rate for MGNREGA workers for the financial year 2022-23 and the hike range from 4 rupees to 21 rupees for various states and union territories. Workers in the 3 states, that is Manipur, Mizoram and Tripura, got no hike at all. It was in response to this wage revision, the MGNREGA and Sangharsh Morcha and the People Action for Employment Guarantee pointed out that average increase in the MGNREGA wage rates across the country was only 4.25%, whereas the central government employees and the pensioners get a DNS allowance of 31% and the cost of which to the exchequer is much larger. Another problem that the scheme has been facing is the problem due to the tech. The NMMS, that is the National Mobile Monitoring Software, which is an app-based online attendance system, has been made mandatory for MGNREGA on work sites and with more than 20 workers. While it was an attempt to reduce corruption, it resulted instead in a lot of work stoppages, with workers losing their attendance and experiencing technical difficulties. Now, what it leads to is the problem that having a smartphone is now a mandatory for the maids to record their attendance on the National Mobile Monitoring Software or the NMMS. However, many women from the poorer household and particularly those belonging from the SC/ST households do not have access to smartphones. Another problem that this was facing is that the medium of language is in English, making it even more inaccessible to the rural women workers. Technical challenges have made the app unreliable. Moving on to the next set of problem, it is related with the insufficient budget allocation. The MGNREGA's success at the ground level is subject to proper and uninterrupted flow of funds to the states. But it has been seen that almost every year, more than 80% of the funds get exhausted within the first 6 months of the budget year. This year also, with 4 months more to go, 59,420 crores has been already spent out of the total 73,000 crore that was sanctioned for the scheme. Now, what happens is that the Rural Development Ministry has asked for the additional sum of 25,000 crore from the Finance Ministry for the anticipated expenditure before the financial year ends. This story, as we have seen, is repeated almost every year, and thus the budget allocation has been proving insufficient. Another issue that the MGNREGA is facing is of payment delays. There have been regular payment delays. The Union Ministry of Rural Development consider wages paid once the FTO, that is Fund Transfer Order, is signed by the second signatory. However, delays take place even in the processing of signed FTOs, for which the MIS, that is Management Information System, does not calculate compensation. Despite of the various orders made by the Supreme Court and the initiatives like GO, that is Government Order by the Union Ministry of Finance, no provision has yet been worked out in the MIS for calculation of full wage delays and payment of compensation for the same. Though in the statute it has been mentioned that there should be compensation for the delays which is more than 15 days. However, no such compensation have been issued. Moving on to the next set of problems or the issues arising from the implementation of MGNREGA is the banking puzzle. The rural banks are highly decapacitated in terms of staff as well as infrastructure and thus always remain hugely crowded. The workers normally have to visit the banks more than once to withdraw their wages. Another set of problem is due to the faulty MIS data. The increase in corruption and weakening accountability has roots in excessive dependence on the implementation of MGNREGA on the MIS, that is Management Information System. There is a growing pile of evidence of how real-time MIS has made MGNREGA less transparent for the workers, has reduced accountability of the frontline functionaries, and aided in further centralization of the program. Another issue that has been highlighted with regard to the implementation of MGNREGA is the issue of non-payment of unemployment allowances. MIS system have been continuously showing huge number of unemployment allowances to be paid. But the inaction from the central government in ensuring payments of the same has shown that the government want to use MIS as per its convenience and thereby not even honoring its own database. Further, it is also seen that the workers are also penalized for the administrative lapses as the ministry withhold the wage payment of workers of the states that do not meet the administrative requirement within the stipulated time period. For instance, submission of the previous financial year's audited fund statement, utilization of certificates, bank reconciliation certificate, etc., and for which the administrative delays of the state are thus transferred on the workers who have not been paid their wages on time. Moving to the next set of challenges that the scheme faces is the issue of job cards. Now, it was also observed under the scheme that genuine job cards were being deleted to meet 100% DBT targets. Genuine job cards were deleted to meet the huge administrative pressure to meet 100% DBT implementation targets in MGNREGA. In the state of Jharkhand, there are multiple examples where the district had later requested to resume job cards after the civil society intervention. Further, there have been too much centralization under the scheme. A real-time MIS-based implementation and centralized payment system has further left the representatives of Panchayati Raj institutions with literally no role in implementation, monitoring, and grievance redressal of the MGNREGA scheme. Last but not the least, the issue that is facing the MGNREGA scheme is the dishonorment of the local priorities. MGNREGA can be seen as a tool to establish decentralized governance, but administration has almost been dictating the implementation. This has become a problem for the locally elected representatives. The government always used the bottom-up approach while planning the strategy to gain political mileage, but have been not honoring its commitment. For example, the linking of MGNREGA to construction of Pradhan Mantri Awas Yojana, individual household toilets, Anganwadi centers, rural hearts have been destroying the spirit of the program, and the Gram Sabha and the Gram Panchayat plans are never honored. This can be seen as a blatant violation of the Act itself. As a last point of critique of MGNREGA scheme, the critics have blamed the scheme for lack of tangible asset creation. And for this purpose, the committee will study if the composition of work taken up presently under the scheme should be changed. The focus will now be to review whether it should focus more on community-based assets or individual works also. There is a need to introduce the changes under the MGNREGA scheme as it is really important as it reduces underemployment in the rural agricultural sector. It is also the last resort for the rural unemployed and also act as a buffer against urban migration. For example, in the absence of MGNREGA, if a worker is not able to find work in their village or during the agricultural lean season, they will be forced to migrate to cities for livelihood and thereby increasing the pressure of jobs in the city. Apart from the economic point of view, MGNREGA is also important from the sociological perspective. It becomes crucial for women also, who form more than 50% of its total employment. Before MGNREGA, in the lean season, women were mostly unemployed, especially in the case of small landholders and peasants. Further, the MGNREGA can also be seen as a scheme that is benefiting the vulnerable section, as nearly 40% of MGNREGA employment goes to scheduled caste or scheduled tribe household. This makes it as an important contributor to social equity in terms of gender, caste, or class. Thus, these issues need to be ironed out at the earliest, such that MGNREGA represents the true nature for which it was introduced. Now, moving on to the next article that has featured in the Hindu on page 9 basically talks about the data protection bill that has been kept open in the public domain. Now, the Digital Data Protection Bill, as argued by retired Supreme Court Judge Justice B.N. Sri Krishna, has said that it is loaded in the favor of the government. We'll try to understand the intricacies of the same. Further, this topic is important for us because it forms both a part of GS2 as well as the GS3 section as issues and the basics of cybersecurity, as data protection is important, and also under the government policies and interventions that are important for various sectors and the issues in their design as well as implementation. Now, it was in 2019 that after the report of Joint Parliamentary Committee which suggested crucial changes, Ministry of Information and Information Technology withdrew the 2019 bill, which has now come up with certain amendments as the form of Draft Digital Personal Data Protection Bill 2022. The new bill has been placed in the public domain for comments from the public. But as per Justice B.N. Sri Krishna, the new bill may encourage the executive to act capriciously and infringe on the fundamental rights of privacy of personal data. Secondly, he says that data board is a creation of the executive with no guideline on its composition, establishment, qualification of its chair and members, and therefore it will be captive to the government with little independence. He also says that the qualification, tenure, and procedure of appointment have also been relegated to delegated legislation and calls the bill as worse than even the 2019 bill. He says that the so-called regulator will be a puppet of the government and will have no independence. Justice B.N. Sri Krishna goes on to explain that the triple test, which was laid down by the Puttaswamy judgment, has been totally abandoned under the format of the new draft data protection bill. The requirement of curtailing the privacy rights of individuals only for necessity, reasonably, and proportionately has been completely ignored. Therefore, he says that bill is fundamentally flawed as it would permit the executive to act and infringe the fundamental rights of privacy of the personal data. Under our discussion, we'll try to understand why there has been a need for data protection law in India. We'll also try to see the various attempts that have been made in this regard for the data protection law in India. And as a part of our discussion, we'll also try to understand in detail what are the various concerns that are associated with the new draft bill that has been kept open for the public comment. Now that we have understood the basic context of the bill, we'll start our discussion that why do we need data protection laws in India. Now there has been a growing level of digitalization. The digitization of society at multiple levels have led to generation of gigabytes of data, much of which is provided by citizens at various platforms, for example at the level of hospitals, in the field of banking, financial services, government agencies, and while purchase of FMCG goods, etc. Now data in general and personal data in specific are at the core of this fast growing digital economy and the ecosystem of digital products, services, and their intermediation. Thus, data can be used by platforms and intermediaries, including personal data of citizens, must be subjected to a framework of laws. The framework of laws should ensure to protect sensitive personal data of citizens, that is, sensitive data like that of health records, financial data, government centric data. Further, a law is needed to ensure that there is no data asymmetry between data principals, that is, data of citizens, and data fiduciaries, that is, who process the data. At the last, the data protection laws are also important in India to ensure autonomy, self determination, and freedom of choice and privacy of the data principal, that is, the data, that is, the citizens. Various earlier attempts were also made in this regard. We'll now understand what were the various earlier attempts that have been made in this regard. Under the K.S. Puttaswamy judgment, declaring right to privacy as an intrinsic part of Article 21, wherein we got the concept of triple test, has changed the perspective on processing and storage of digital data of citizens, which is taking place at an unprecedented level. After the judgment, the Personal Data Protection Bill 2018 was proposed by Justice Sri Krishna Committee. But multiple changes in this 2018 bill was introduced and was reintroduced in 2019 as Personal Data Protection Bill. However, this bill was later recommended to Joint Parliamentary Committee, which suggested a new draft data protection bill in 2021 by making multiple changes in the 2019 bill. The government in August 2022 withdrew the Data Protection Bill 2021 as the Joint Parliamentary Committee had recommended extensive changes in the 2019 draft law. So we can see the trajectory that first the 2018 Justice B.N. Sri Krishna Committee proposed a bill. This was reintroduced in 2019 as Personal Data Protection Bill. This was further referred to the Joint Parliamentary Committee, which suggested a new data protection bill and made certain recommendations to be made under the 2019 bill. At last, in August 2022, government withdrew the bill, and now the government has again reintroduced a draft bill and kept it in the public domain to invite comments from the public. Now the new bill has certain important definitions. There are various definitions regarding data, data fiduciary, what do we mean by data principal, personal data, account of personal data breach, processing, and public interest. This is provided in detail under the PDF, which is uploaded in the description. We'll only see the most important definitions that have been provided under the new bill. The first important definition here is of data fiduciary. Now, data fiduciary means any person who alone or in conjunction with other person determines the purpose and the means of processing of personal data. Now, the central government may notify any data fiduciary or class of data fiduciaries as significant data fiduciary on the basis of assessment of relevant factors. And these relevant factors are the volume and the sensitivity of the personal data, risk of harm to the data principal, that is to the citizens, potential impact on sovereignty and integrity of India, risk to the electoral democracy, security of the state, public order, and such other factors as the central government may consider necessary. So we can see that the central government has been given the power to notify the data fiduciary. The second important definition here is that of data principal, which means the individual to whom the personal data relates and where such individual is a child includes the parents or lawful guardian of such a child. Basically, it translates to one who owns the data or whose data is being processed. The draft bill also gives the definition of data, which means a representation of information, facts, concepts, opinions, or instructions in a manner which is suitable for communication, interpretation, or processing by humans or even through automated means. For rest of the definition, please refer to the PDF provided. So now that we have seen the important definitions that have been provided in the new bill, we'll try to understand what are the various concerns that are associated with the bill. The major provisions of the draft bill has also been listed in the PDF. Please read them. But since the bill is in draft condition, we'll go through the major provisions of the bill once it is tabled and passed. We'll just try to understand the various concerns for now that have been highlighted in the new bill. First, we'll see the concerns at a glance and later discuss them one by one in detail. The various concerns that have been associated with the bill is the inapplicability of the bill on manual data. Secondly, there is a lack of data portability rights. The right to be forgotten has been subsumed in the new data bill. Further, there is also a conflict of interest under the new bill as the rule-making powers have been provided with the central government. Government will emerge as the biggest data fiduciary from this bill. There is a lack of clarity on what needs to be done in the process of data breach. Further, the concept of sensitive personal data, which is the most contentious, has been done away with. There has also been exclusion of citizens who are not located in India. There is a lack of categorization of personal data, which eases data localization norms. Another issue that has been highlighted also by even B.N. Sri Krishna is the issue of Data Protection Board, which will work at the mercy of the central government. And there are also some concerns regarding the penalties and the compensation that have been mentioned under the new Data Protection Bill. Now we'll discuss the concerns one by one and starting our discussion with that of issue of manual data. As per the draft Data Protection Bill, the law is inapplicable on the data that is to be processed manually. Thus, this accords lower degree of protection as the previous draft excluded only data processed manually by small entities and not generally. Now, there has been a general exclusion of manual data and not that of small entities. The second concern here is the portability right. The data portability rights allow data principal to receive data in a structured format. That is, all the personal data they have provided to the data fiduciary for processing. Meaning thereby the citizen could have asked for the data in the structured format if the data principal or the citizen was not satisfied with the social media platforms that they were currently using. And they could have requested for porting of their data to another social media platform and avail of its services without having to provide the personal data again. But the 2022 bill does not provide for this right. The third contention issue here is the right to be forgotten has been subsumed. The right to be forgotten was an important part of the privacy law and has been duly recognized even in the Puttaswamy's judgment that we have earlier discussed and also in general data protection regulation of the European Union. Under the right, the data principal can ask the data fiduciary to stop disclosure of their personal data. However, the 2022 bill has subsumed the right, meaning thereby there is a combination of two rights which is specific to the disclosure of personal data. This compromises the freedom of speech and expression of the other individual. Further, a lot of critical information will be governed the true scope and exemptions of the law are left for the subordinate legislation through rulemaking which will be notified later by the central government. Moving on the next set of concern, it is with regard to the conflict of interest and government as data fiduciary. Now there is a conflict of interest because out of 22 clauses of the new data protection bill, the central government has been provided rule-making power in around 14 clauses. This becomes problematic due to several reasons as government will be one of the largest data fiduciaries. It processes data of millions of India for provisioning of services and the benefit and issuance of permits, license and official IDs. The second cause of concern here is a government as a data fiduciary only. As government as data fiduciary operates as at a higher ground when compared to other data fiduciaries. Government can make rules on data protection obligation of data breach, data protection impact assessment, data audits, information that can be requested from a data fiduciaries which the government will itself be subject to in its capacity. Thus, center will exercise greater control over the data protection. This creates a situation of imparity. Further, there is lack of clarity on the process of data breach. For example, in case of personal data breach, the data processor has to notify the regulator and the individuals in such form and manner as may be prescribed by the central government. This allows for arbitrary decision making on case-to-case basis. Moving on to the next, it has led to the protection of sensitive personal data. The concept of sensitive personal data has been done away with in the new bill. The 2019 bill defined sensitive personal data as such personal data relating to financial data, official identifier, sex life, sexual orientation, intersex status, caste or tribe, religious belief, political beliefs or affiliation. But the 2022 draft law has removed the additional protection measures which was earlier accorded to the sensitive personal data. There has been an exclusion of citizens, as new law exclude the data collected from citizens who are not located in India. This would impact statutory protections that are available for clients of Indian startups operating overseas, thereby impacting their competitiveness. Further, there has been also issue regarding the data protection board, as center will be exercising greater control over this data protection board in matter relating to the appointment of the members, term of their employment, condition of their employment, and the functions that are to be performed by the data protection board. All these will corrode rule of law and principles of natural justice. Further, the bill also provides for exemption on the national security ground. Under the proposed bill, the central government can issue a notification to exempt its agencies from adhering to the provision of draft law for national security reasons. The consent by the citizen allows data fiduciaries to take all kind of data without any limitation, and thus the collection of personal data is contingent on consent of data principal, that is the citizen. Thus, the consent allows data fiduciaries to take even those data which are not needed by them. For example, a photo filter app may process data related to our location or information on our contacts, even though it may not require such an information to carry on its primary task of applying the filter. These are the cause of concerns that have been highlighted under the newly proposed bill. With regard to penalties, there is no provision for compensation under the new bill, as it does not allow citizens to seek compensation from data fiduciaries from harm suffered due to unlawful processing of data. So these were the concerns that were associated with the new data protection bill. We'll have a further discussion on the same when it is introduced in the parliament and pass through it. Moving to the last topic of the day that has featured in the Hindu on page 1, basically talks about the issue of surcharges and cess, over which center has shown a large reliance in the recent year while raising the revenue. Now this area is particularly important as it falls in two categories of GS2 as well as that of GS3. In the GS2 section, it highlights the problem of fiscal federalism between center and the state, that is, the issues and the challenges pertaining to the federal structure. And in the GS3 section, it highlights the issues of mobilization of resources and also the issue of government budget. Now recently, several state government has urged the center to rein in its reliance on raising revenues through cesses and surcharges that reduce their share in the divisible pool of taxes. They also sought greater fiscal support to help revive the economy and reiterated demands for extending the goods and service tax compensation period. These demands or issues were highlighted along with states' local project at a consultation meeting for Union Budget 2023-24. Several ministers, including that of Tamil Nadu Finance Minister, noted that the share of cesses and surcharges had grown from 10.4% of gross tax revenue in 2011-12 to a level of 26.7% currently in 2021-22. And this has deprived the states of their legitimate share of revenue that is being collected by the union government. The cess and the surcharge imposed and collected by the center do not form the part of central divisible pool of taxes. They are not distributable among the states and hence continue to remain with the center. Over a period of time, the center has been imposing large number of surcharges and cess to mobilize the revenue. A case in point can be taken with the introduction of agri-infrastructure cess in the Union Budget 2021-22 only. So during our discussion, we'll try to understand what is cess, how it is different from the tax, and the differences between the surcharge and the cess. Now we'll try to understand the definition of the cess and surcharge. Cess and surcharge are imposed and collected by the center and do not form the part of central divisible pool of taxes as we have already discussed. And we have also seen that over a period of time, center has been imposing large number of surcharge and cess to mobilize their revenue. A case in point of which was agri infrastructure cess that was introduced by the central government in Union Budget of 2021-22. A cess is therefore considered to be a tax on tax. It is levied by the government for a specific purpose, and cess collected for a particular reason has to go towards the purpose for which it was charged. This means that the cess cannot be used or diverted to other purposes. For example, the health and education cess is imposed at 4% on major central taxes such as corporate tax and income tax. It is to be used only for the promotion of education and health and cannot be diverted for any other purpose. So this brings us to the question, how is it different from other taxes? Any tax which is collected goes into the Consolidated Fund of India, which can be allocated for any purpose. However, cess is a different form of tax and maybe initially get credited to Consolidated Fund of India, but has to be ultimately used for the purpose for which it was imposed, which we have already seen as an example of the education cess. In order to utilize the cess proceeding, the government has to create a dedicated fund for the same purpose, and the proceeds of such funds are non-lapsable. So we have seen that cess cannot be utilized for any other purpose. We have also seen that they are not lapsable, and we have also seen that there needs a creation of dedicated fund for the same purpose. An example of which can be seen as a Prarambhik Shiksha Kosh for primary education, Madhyamik and Uchchata Shiksha Kosh for secondary and higher education. Further, unlike the normal taxes, cess fund need not to be shared by the central government with the state government, which has been the cause of concern or the contention between the center and the state, which state says distort the fiscal federalism as they have been deprived of their fair share. And we have also seen in our initial discussion that the share of cess and surcharge has been increasing as its proportion to the total revenue collection was 10.4% in 2011-12 and has now grown to a level of 26.7% in 2021-22. Government also resorts to cess as it is easy to introduce, modify and abolish as compared to normal taxes, as any change in normal tax need to go through a lot of procedure. Thereby, the ease with they can be introduced and removed also promotes the government to introduce them. As the last part of our discussion, we'll try to understand the difference between the cess and the surcharge. Now, surcharge can be seen as an additional tax, whereas cess is seen as tax on tax. Surcharge is imposed when income level above a certain threshold is achieved, whereas cess, on the other hand, is imposed on the payment of tax. For example, the surcharge is imposed at a threshold level when the income is greater than 50 lakhs and less than 1 crore at a level of 10%. When the income is greater than 1 crore and less than 2 crore, it is imposed at a level of 15%. When it is greater than 2 crore and less than 5 crore, it is imposed at a level of 25%. And when the income is greater than 5 crore, it is imposed at a level of 37%. Whereas cess is imposed as a payment of tax, that is a 4% health and education tax on major central taxes is imposed such as corporate or income tax. Health cess is also imposed on the imported medical devices, and the road and infrastructure cess, that is rupees 10 per litre on imported and domestic sale of petrol and high-speed diesel is imposed. So this brings us to the point where how it is calculated. Now the surcharge is calculated as a percentage of income tax, where on the other hand cess is calculated as a percentage of income tax and surcharge. Next comes to the point, where does the surcharge goes? So the surcharge goes to the Consolidated Fund of India, whereas cess on the other hand may initially get credited to the Consolidated Fund of India but is transferred to a separate dedicated fund outside Consolidated Fund of India, which we have already discussed, and we have also seen that it remains non-lapsable. Surcharge can be utilized by the government as per its prerogative, that is, they can use as per their needs and demands, But cess, on the other hand, is utilized for the purpose for which it was collected. For example, the education cess can be utilized only for the education purpose. The thing in common between cess and surcharge is that both forms the part of central government tax only. That is, they are not a part of central divisible pool, and therefore states do not get any share from these taxes that are collected. With this, we have understood what is the demand made by the state governments, and we have also understood the concept of surcharge and cess in detail.